At 6:12 in the morning, the pounding starts. Not a doorbell, a fist, hard enough to shake the frame. Outside, voices say they are ICE. They need you to open up. They just want to talk. Clear a few things up. Your first instinct is to crack the door, show your face, prove there is no problem. But in that second, fear can become permission. Because the first thing most people do feels harmless, but legally, it can change everything. I am an immigration lawyer, and I want you to understand the sequence before the fear takes over. Not how to argue, not how to hide, the sequence. Because the common assumption is wrong. A badge, a jacket, and an official-looking paper do not automatically mean you must open your door. What matters is what kind of authority they actually have, and what you do before you can verify it. In the next few minutes, you will know what not to do first, what to ask for, which document changes the situation, and the exact words to say through the door. The first legal line is physical, simple, and surprisingly powerful: the closed door. If agents are outside, keep the door closed. That is not being rude. That is not resisting. That is using the first boundary the law recognizes, the entrance to your home. Say it through the door, calmly. I do not consent to entry. Please slide any warrant under the door or hold it up to the window. Those words matter because consent changes the situation. If you open the door wide, step aside, answer questions in the doorway, or let agents cross the threshold, they may later argue you allowed it. And once that line is crossed, everything becomes harder to unwind. The reason is the Fourth Amendment. Your home gets the strongest protection. In general, government agents need one of three things to enter: your consent, an emergency circumstance, or a valid judicial warrant that authorizes entry. A knock is not enough. A command is not enough. Even the word ICE is not enough. So the first move is simple. Do not unlock the protection before you have seen the authority. But the word warrant is where many people get trapped, because not all warrants are the same. Here is the test. Look at who issued the paper, and look at who signed it. A judicial warrant usually comes from a court. It may say United States District Court, State Court, or Magistrate Court. The key detail is the signature. A judge or magistrate. That kind of warrant can authorize agents to enter a home or private area, if it actually says so. An ICE administrative warrant is different. It may look official. It may have a seal. It may say Department of Homeland Security. It may be a form called I-200 or I-205. But if it is signed by an immigration officer, not a judge, that document generally does not, by itself, give ICE the power to force entry into your home. That is the trap. The bad response is seeing official paper and thinking, they have a warrant, so I have to open. The good response is keeping the door closed and asking them to slide it under the door, hold it to a window, or show it to a camera. Because the question is not, does it look serious? The question is, did a judge authorize this entry? And even when the paper looks real, the next question is whether it actually covers your home, your name, and that moment. So now you are looking at a real judicial warrant. Do not treat that as the end of the conversation. Treat it as a map. Check the address. Check the names. Check the date. Check the judge's signature. Then look for the words that say what agents are actually allowed to do. A warrant for apartment 2B is not a warrant for apartment 3C. A warrant for one person is not automatically permission to question everyone in the room. A warrant to seize specific documents is not a blank check to search every drawer, phone, backpack, and bedroom. That boundary matters because the Fourth Amendment is built around particularity. The paper is supposed to describe the place to be searched and the people or things to be seized. Not just this building, not just whoever is inside. Specifics. If you want calm, practical breakdowns of what legal papers actually allow, subscribe to the channel. The bad move is grabbing the paper, arguing, blocking the doorway, or trying to physically stop agents once a judge has authorized entry. That can escalate fast. The better move is calm and clear. I do not consent to any search beyond what the warrant authorizes. Say it out loud. Repeat it if needed. Document what happens if it is safe, because even a valid warrant has edges. But the door is only one part of the encounter. The next danger is what comes out of your mouth. What you say next can become the case against you, not because you confessed to a crime, because you answered a simple question. Where were you born? How did you enter? What is your status? Who else lives here? You generally have the right to remain silent. You do not have to explain your birthplace, your immigration history, or how you entered the United States. And the safest answer is not a story. It is a sentence. I choose to remain silent. I want to speak with a lawyer. I do not consent to a search. Say it calmly. Say it through the door if you have not opened it. Say it again if the question changes. The bad move is guessing, joking, arguing, or trying to talk your way out. Casual answers can become evidence in immigration proceedings. And lying, handing over false documents, or signing something you do not understand can create separate problems. That last part matters. Some papers can waive rights. Some can accept removal. Do not sign without legal advice. Rights are strongest when you use them before panic turns the moment into permission. The same principles follow you beyond the home, but the rules change slightly when the knock comes at work. At work, the door is not always one door. If agents walk into a restaurant dining room, a store lobby, or a front counter open to customers, they may usually stand there like any member of the public. That does not mean they can go everywhere. The line is the private area, a kitchen, stockroom, office, employee-only hallway, or back worksite generally requires consent or a judicial warrant. Not just a badge, not just pressure. A real judicial warrant is signed by a judge and names the place to be searched. The smart move is boring and planned. One trained person speaks for the business, asks for identification, asks to see the documents, makes a copy if possible, and calls a lawyer. Everyone else stays calm and does not interfere. The dangerous move is accidental permission. A manager waves agents into the back because they sound official. A worker opens a locked door. Someone starts pointing people out. Even if agents are lawfully in the building, employees still keep individual rights. They can remain silent. They can ask for an attorney. An administrative warrant for one named worker does not automatically require the employer to lead agents to that person, though nobody should hide or harbor anyone. So the real enemy is not just ice at the door. It is confusion in the first 30 seconds. That is the turn. The law does not only ask what agents did, it often asks what you allowed. A door opened wider. A sentence like, "Okay, come in." A nervous nod toward the hallway. None of that feels like a legal decision in the moment. It feels like fear trying to end the situation faster. But panic can turn a boundary into permission. That is why calm matters. Not because calm makes you safe. Because calm gives you time to say the line clearly. I do not consent. I choose to remain silent. Please show me the warrant. Rights are not magic words. They are boundaries, stated before panic takes over. Now we can answer the question from the doorway. What exactly should you do first? Here is the doorway checklist. Do not open first. Speak through the closed door. Ask, do you have a warrant signed by a judge? If they show paper, ask them to slide it under the door or hold it up to a window. Look for the word court. Look for a judge's signature. Check the correct name and address. If it is not a valid judicial warrant, say, I do not consent to entry. I choose to remain silent. I want a lawyer. Then stop talking. If it is valid, do not block them. Do not argue at the doorway. But do not give permission beyond what the warrant allows, and do not answer questions without counsel. Save this checklist. Share it with someone who may need it before the knock comes, and comment the exact sentence you would say through the door. Thank you for watching.